Judicial, International, Argentum Exploration Ltd and Popplewell of the Republic of South Africa.
Thank you. We're very sorry to have kept you waiting. As often in this case, we couldn't resist talking about it. You'll be aware that I'm not the Master of the Rolls, and we've got Lady Justice Elisabeth Laing, and obviously she has had a more limited opportunity to absorb the material in the case than my lady and I have, and you'll bear that in mind in the course of your submissions. Have you reached a final resting point on who's going to say what in what order, as it were? Who's going to address what in what order?
My Lord, as the appellant, perhaps if I can address that, and the answer is yes.
Yes.
My learned friend, Dr. Straker, for the intervenors, subject to the court's approval, will go first because he's going to address essentially the new points arising.
Yes.
We estimate that he will be about an hour and 3/4. I will then follow, dealing with the new points arising. So they are all got out of the way, as it were, before my learned friend, Mr. Hofmeyr, continues with the submissions that he had started on the last occasion. And I have indicated to Mr. Hofmeyr that I expect to be about an hour and a half between the time I have today and tomorrow before he starts tomorrow, and keeping the rest of my time, which we've divided up equally, again, subject to the court's approval, for my reply in due course.
Thank you. There appears to be some suggestion, which I wasn't fully au fait with, that there would be some part of these 3 days in which the court was unable to sit. I don't think that is still the case. That may have been something to do with the MR's timetable.
I think we were all proceeding on the assumption that we were not sitting this afternoon.
My Lord, that is right. On the other hand, if there's no reason why we shouldn't continue, I'd be quite happy to do so, but entirely in the court's hands. And my learned friends, if it's a matter of difficulty for them.
Yes, I think that must have been something to do with the MR's arrangements.
We were originally listed for 2.5 days, half a day today, and then a full day tomorrow, and a full day the day after.
Does it cause any difficulty going through this afternoon?
I don't envisage any difficulty at all, my Lord, subject, of course, so Mr. Hofmeyr will be on his feet rather early than he expected.
Good, well then let's do that. Yes, Dr. Straker.
May it please the court, I appear for the intervenors, the Secretary of State for Transport and the receiver of REC, the latter having been appointed under section 248 subsection 2 of the Merchant Shipping Act 1995 and who exercises statutory functions, various of which will be the subject of submissions today. The intervenors intervene only in relation to certain of the issues in the agreed list of issues. The intervenors have no interest in whether the appellant or the silver is entitled to any form of state immunity. The interest of the intervenors is the issue of what are the powers and duties of the Secretary of State and the receiver of REC, where REC is held by or to the order of the receiver of REC, and an owner claims to be entitled to state immunity. And essentially that's issues 1, 2, 4 and 5 on the agreed list of issues. Today I present the submissions of the intervenors on those issues. In addition, the intervenors have respectfully expressed the hope that should the court not accept those submissions, nonetheless, as a result of the judgment in this case, they will have very clear guidance as to what their powers and duties in this situation are. I'd say also the submissions that I will be making today are based almost entirely on the wording of the Merchant Shipping Act 1995, with some references to the predecessor act, the Merchant Shipping Act 1894, a few other references, but there is no case law directly on point. The three key provisions, I'll be taking you to all the relevant provisions later, but the key relevant provisions are section 226, subsection 2, paragraph B, section 236, subsection 1, and section 239, subsection 1. In the agreed list of issues, they're referred to as the MSA provisions. They're the ones that are key in relation to these issues. Because there are so many legislative provisions, I will take you to them in due course and deal with them all at once. But I propose to begin by introducing what the issues are and what the submissions of the interveners are, so that we can see what I'm asking the court to see when we do look at the legislative provisions. The starting point is that where somebody finds or salvages wreck, and they are not the owner of that wreck, then it still belongs to the owner, and the owner is entitled to their property. But the finder who has gone to the effort of salvaging it is entitled to a salvage award. And the provisions of the Merchant Shipping Act provide that if wreck is found outside the United Kingdom and the finder brings it within the United Kingdom, then they must give notice to the receiver of wreck and must then, according to whichever direction the receiver gives, must hold it to the order of the receiver of wreck, or must deliver it to the receiver of wreck. That's section 236, subsection 1, which is one of the key provisions I referred to. That provision on its face applies whether the finder is entitled to a salvage reward or not. But in addition, we have section 226, which is another of the key provisions, which says that if salvage is due, then the receiver must detain the wreck. So then the next thing is if an owner comes forward within a year and claims ownership of the wreck, the default provision is section 239, subsection 1, which is the third of the three key provisions for present purposes. The default provision says that if the owner pays a salvage reward to the finder and any other fees and expenses, the receiver will deliver the wreck to the owner. So the owner is entitled to have the property returned, subject to payment of a salvage award. Now, it's not stated in the legislation, but in practice, other outcomes are possible by agreement between the parties. So, of course, an owner and a salvor might agree that rather than the owner pay a salvage award to the salvor and keep the property, that the salvor might take the property and pay an owner's share to the owner. Or they might mutually agree that the property should be sold and the proceeds be divided as agreed between them. But the default provision set out in the legislation, section 239, subsection 1, is that if nothing else is agreed, the receiver detains the wreck and until the owner pays salvage to the salvor, after which the receiver will deliver the wreck to the owner. And that's where we come to the question that is the issue in this case. What happens if the owner says, I'm a foreign state, I am entitled to state immunity, or the wreck is entitled to some kind of immunity under international law? What then are the powers and duties of the receiver of wreck and the Secretary of State? Now, before getting into that issue, I would, as a preliminary matter, say that there are three things that the interveners say the receiver of wreck cannot do. The three negatives. The first negative is that the receiver of wreck cannot make a decision on whether the foreign state is entitled to state immunity in a way that would be binding on the foreign state or the salvor. And I think that's common ground. The second negative, and this second negative applies whether the owner is a state or any normal owner, is that the receiver of wreck cannot decide who is the owner of the wreck in a way that would be binding on the purported owner or the salvor. Now that's something that I understand may not be common ground between the parties, but that is the position of the receiver of wreck.
Well, it may depend on what you mean by, in a way, binding on the purported owner or salvor.
Well, the proviso is this, again, we'll come to the legislation, but section 239, subsection 1, says that if a person claiming to be the owner satisfies the receiver of wreck within the stipulated time limit that they are the owner and they've paid the salvage, that the receiver of wreck will deliver the wreck to that person.
So to that extent, the receiver does have the power to determine ownership.
The receiver has to make a determination of whether the receiver is satisfied as to who the owner is in order to decide whether to give the wreck to that person or not.
Yes.
But there is another statutory provision, which again will come to section 244, subsection 2, which says that is without prejudice to the rights of other parties. So the receiver discharges the receiver's duty by doing that. But if somebody else said the person to whom the receiver has given that property is not in fact the owner, I claim to be the owner, that's a matter that could be litigated before the courts. The receiver's decision or the receiver's satisfaction, the fact that the receiver was happy to hand the property over to that person, is not a binding legal determination of ownership.
Isn't it? It's not a binding legal determination of ownership for all purposes, but it would bind any rival claimant to ownership in the sense that they would be unable to prevent the receiver from fulfilling the terms of the receiver's statutory function, which would be to release the cargo to the person to whom he or she was satisfied was the owner.
I suppose in theory, the decision of the receiver to be satisfied that someone is the owner and to hand property over might be something that ends up being judicially reviewed. But I think the point is that if the receiver makes that decision and hands the property over, that is a decision made by the receiver for the purposes of the discharge of the receiver's statutory duty.
Yes.
It is not a determination for purposes of private law of property.
No.
So that was my second negative. And the third negative, which I understand may be very much in dispute in these proceedings, but the intervener's position is that the receiver cannot determine the amount of the salvage reward in the event that this is in dispute between the parties.
Even in a case of unclaimed wreck from UK waters?
No, unclaimed wreck is a specific exception. So unclaimed wreck, there is a specific statutory provision, and in fact it doesn't say that the receiver of wreck determines the salvage award. It says that the Secretary of State determines the salvage award.
Well, yeah, right.
Yes.
Come to that.
So,
Can I just ask you a little question, just following on from your third negative, please, Dr. Staker? It's this. Say the receiver can't determine the amount of the salvage award. On your submissions, can the receiver decide whether or not salvage is in theory due?
my submission on that would be that if the salvor claims salvage, the receiver would have to detain the wreck until there has been some kind of determination of what the salvage reward will be. Because the receiver cannot determine that. And if the receiver cannot determine that, there are two possibilities. One is the receiver would say, I can't determine whether salvage is due or not, or how much it would be, therefore I can't detain the wreck.
Yeah.
And that would totally defeat the purpose of those legislative provisions.
Yeah.
So the receiver would say there is a salvage claim, it hasn't been determined, therefore I can't determine that the salvage has been paid, therefore I cannot release the wreck.
Yeah. So in other words, the existence of a claim is enough to trigger his powers to detain?
Yes.
Okay, thank you.
And we say that's a simple matter of reading the legislation, that you would need a statutory power to be able to make a binding determination of the salvage reward. There is no provision in the legislation giving that power.
Does it follow from that if you're under an obligation to detain the wreck because there is a claim to salvage, you say that the receiver has no power to determine that claim, then unless and until that claim is determined, the wreck stays in the hands of the receiver and there is no power to release it?
Yes. Yes. Subject to the limitations period in my submission for bringing a salvage claim. So there is a limitations period for bringing a salvage claim, a 2-year period. And my submission is that if no claim has been brought within the limitations period, then the situation is the parties are not agreed on a salvage reward. It's no longer possible for a court to determine a salvage reward. Again, this isn't stated expressly in the legislation, but it would defeat the purposes of limitations periods if the limitations period for bringing a salvage claim had expired, and yet nonetheless the receiver would detain the property in perpetuity.
Well, let's just explore that. Sorry.
When you say a claim is brought, do you mean a claim is made against the receiver that salvage is due, or do you mean a claim is brought in court proceedings within the 2 years?
Well, it would be the normal way in which things would happen would be, yes, it would be court proceedings. It's the limitations period is a period for bringing court proceedings.
It is. And the limitation period arises under the Salvage Convention and
Yes.
is expressly
Yes.
tied to the,
Yes.
the commencement of proceedings.
Yes.
So it doesn't matter whether a claim is made against the claim for salvage is made to the receiver of wreck, there have to be proceedings brought within 2 years.
Yes. And if proceedings have been brought within 2 years, then there will still be a pending claim, and the receiver, again, will not be in a position to determine the salvage reward. We'll have to await the outcome of those proceedings. And again, when we come to it, we'll see there are legislative provisions that says if a salvage reward is agreed between the parties, or if it's been decided by the court, finally, and the owner doesn't pay the salvage reward, then the receiver has a statutory power to sell the property, to pay the salvage, and to give any net proceeds to the owner. So my submission would be that is the way that the Act envisages that this would operate. That if proceedings are pending in court, then the receiver would continue to detain the property in that period. When the proceedings are final, the salvage would be paid, and if it's not, the receiver has the power to sell the property and to enforce that decision as to salvage. But that if no proceedings are brought within the limitations period, then we have a situation, the parties aren't agreed on a salvage reward. The salvor can't do anything to bring about payment of a salvage reward. And in my submission, the way the legislation works, the conclusion should be that in those circumstances, the salvage is deemed no longer to be due. And that being the case, there is no longer an obligation to detain under section 226. And under section 239, where it's stated that the receiver will deliver the wreck to the owner on payment of the salvage, my submission is that means any salvage that may be due. So salvage will no longer be due, limitations period's expired, the receiver would deliver the property, deliver the wreck to the owner.
Due here means not, strictly speaking, due in law, but due in the sense of capable of enforcement in a claim in court.
In effect, I've already made the submission that when the wreck is first brought to the United Kingdom and the receiver has to exercise statutory powers, due doesn't mean due. Due means a claim has been made. So if salvage proceedings are brought in court, it may well be the court says the salvor has no right to a salvage reward because whatever, under Article 18 of the Convention, they created difficulties and it's their whatever. But they're not entitled to a salvage reward. At that point, the receiver would release the wreck, but it will have been the case that the receiver has detained the wreck during the course of the court proceedings.
So sorry to interrupt you, just pausing there. Salvage due in relation to initial detention,
yes,
means a claim has been made to the receiver that salvage is due, not that a claim has been made in court.
It would initially mean claim made to the receiver.
Yes, the receiver would be bound to detain it
Yes.
if a claim was made that salvage was due to the receiver,
Court,
even
yes.
if court proceedings hadn't yet been commenced.
Yes, because there's a limitations period for bringing court proceedings. The fact they haven't been brought yet doesn't mean that they can't be brought or they won't be brought. And again, it would defeat the purposes of the legislation if the receiver said, you haven't brought court proceedings yet, I'm not going to detain it.
So salvage due for the purposes of section 226 means salvage claimed to be due in a claim made to the receiver.
Yes.
But when we come to release, I think you're saying salvage due means salvage which is capable of being held to be due in court proceedings.
Yes. So ultimately, it's a practical provision. At the starting point, due doesn't mean legally due, it means claim to be due. In reality, it may turn out not to be due. It may turn out that the salvor is in fact not entitled to a salvage reward, which will mean that the receiver will have been detaining this wreck, notwithstanding that no salvage was due. But the point is the receiver didn't know that at the time. So due has a practical meaning. It means salvage may be due.
Well, what I'm struggling with at the moment is why it doesn't mean the same thing throughout the Act. Sorry to put it so bluntly, but if that's what it means for the purposes of detention, why doesn't it mean exactly the same thing for the purpose of retention?
Well, in fact, in a sense, it couldn't. It perhaps couldn't have that meaning. It's due. Due at the outset means claim to be due. At the other end, it can't mean claim to be due, because that would mean that the receiver would have to continue to detain the wreck, even though a court has determined there's no entitlement to a salvage award, because the salvor still claims that it's due.
No, he can't still claim that it's due once the court has decided that he's not entitled to it. There is no extant claim.
Yes. I mean,
But if he's still claiming that it's due and the court hasn't determined it, at the moment I'm struggling with the idea of due meaning something different.
Yes, it doesn't necessarily mean something different. It depends on how one defines what that meaning is. For the definition perhaps would be due means that there is a possibility that the salvor will be in a position to enforce a salvage claim against the owner. If that possibility exists, then the wreck is detained, because that is a measure that will enable the salvor to enforce any salvage reward that in practice, in the real world, that the salvor may be able to obtain, and that in the real world the salvor will be looking to have enforced.
I'm sorry, but due can't mean possibly enforceable. Due means owing, as a matter of law.
Well, Dr. Staker, you potentially helped by the introductory language of subsection 1 of section 226, where salvage is due to any person under this chapter, the receiver shall, and also by the presence of subsection 3b1. So subsection 3 is dealing with security, and it says that the receiver can release property detained under subsection 2 if the security is given to his satisfaction, or where the claim for salvage exceeds £5,000, and any question raised as sufficiency of security. So it does seem, doesn't it, as though section 226 is might be dealing with claims.
I mean, my submission would be that all of these provisions are looking at claims.
Yeah.
So that if a claim is made, the wreck is detained. And if a claim can no longer be made, then the purpose of detaining the wreck is no longer there.
Well, I understand entirely that's what you say section 236 means, that it must at that stage
Yes.
be applying itself to claims for salvage. But you're saying when you get to section 239,
Yes.
and it's a question of retention,
Yes.
a claim for salvage being due isn't sufficient.
For 239.
For 239. So that if you have a case in which the salvor has said, I claim salvage, and the court has said, you may be entitled to salvage, but we can't as a court hear that claim. You say in those circumstances, in 239, the salvage is not due, even though it is still claimed to be due.
Well, if Section 239 doesn't use the word due.
It does, doesn't it?
It says,
on paying the salvage fees and expenses due.
Yes, I apologise for that. Yes, well, my submission would be that due here has the same meaning as in 226. So that it's also talking about claims, because, first of all, 239...
But sorry, just before you say why that's the case, does that have the consequence that if a salvor makes a claim to salvage in court proceedings, and the court says we can't hear those proceedings because it's the claim against the state owner and the state has immunity, doesn't decide anything about the underlying entitlement to salvage, just says as a court, because of the way immunity works, we can't hear that claim, then I think if what you've said just right, there would still be a claim to salvage due, and it would mean, in those circumstances, that the receiver couldn't release the cargo.
No,
indefinitely.
If due means that there is the possibility of a salvage reward being obtained such that the salvor would be looking to enforce it, then these are the provisions that provide a mechanism for ensuring that that salvage reward is paid. If there is no longer a possibility of that happening, for instance, because the limitations period has expired, or because the owner has state immunity, the intervenor's submission is that the wreck would at that point be delivered to the owner. Because the purpose of detaining it is no longer there. And if it is not possible any longer to enforce, to obtain a binding salvage reward in a court, the question is what purpose would it serve to continue to detain the wreck? Because in my submission, there is no other mechanism for determining a salvage reward that would be binding and could be enforced.
Which is the question we have to decide.
Which is the question we have to decide, precisely. But if it's accepted that the receiver does not have that power, then the result of any other interpretation would be that the salvor is not in a position to obtain or enforce a salvage reward against the owner, and yet the owner's property, the wreck, continues to be detained. And for how long? Potentially in perpetuity. And what would the owner have to do to get it released? Well, the owner would somehow have to get a binding salvage reward that would be binding on the salvor. And at that point, because there's no court that could determine that, presumably the salvor holds all the cards. The salvor would not have to agree to anything.
Well, I think Mr. Hoffman's point is that the owner can bring an action seeking release of the cargo, in which there wouldn't be immunity because the salvage reward would be determined. Yes, and
the two main points in response to that would be, first of all, the legislation makes no provision for that at all. There is no suggestion that in any circumstances an owner would have to bring an action for delivery up in order to have the wreck restored to their possession.
Likewise, there's nothing that actually specifically says that you'd have to hand it over in those circumstances.
In section 239, there is an express right of the owner to have the wreck delivered to them.
Yes, but
And it says-
upon
Yes,
various conditions being fulfilled, so it
Yes.
becomes a circular point.
yes. Well, perhaps it does become a circular point, but
But I mean, one way of reading 2391 is to say that the owner can come along, and if it's been established in a court that no salvage is due, then the owner can say, well, give it to me, please.
Yes, my submission is 239, when it says on paying the salvage, it means on paying such salvage as may be due.
That's my point, yeah.
Yes, exactly. It's not laying down. It does not lay down any substantive right to salvage. It doesn't create a substantive right to a salvage reward. That is found elsewhere in the legislation, and it doesn't create a mechanism for determining the amount of the salvage reward.
I understand that, but what makes it that more complicated to apply, if I can put it as neutrally as possible, is that in a case of state immunity, the court is not deciding that salvage is not due. It is simply saying, we, the court, must refrain from embarking upon the exercise.
Yes.
So the salvage may be due.
Yes.
In fact, it probably almost certainly would be due, because otherwise the state wouldn't be claiming state immunity.
I would say it's much the same as a limitations period. In substantive law, it may or may not be due, but the fact is the limitations period's expired. The salvor can no longer get a binding court determination of a salvage reward, therefore can't enforce a salvage reward. This is whether the owner is a state or not. My submission would be that it would defeat the purpose of limitations periods. It would defeat the purpose of limitations period if a salvor was out of time to bring a salvage claim in court, and said yet nonetheless the receiver has to continue to detain the wreck because salvage is due, potentially forever, until the owner brings an action for delivery up, and then the limitations period won't apply anymore.
Why not? Why wouldn't limitation be a complete defence?
Well, if the
So the owner brings an action, and the salvor claims, counterclaims salvage, and the owner says it's too late, you're time barred.
yes, I
Owner
would.
wins.
Yes, well, what is being said then is the limitations periods are still effective, notwithstanding the action for delivery up, and notwithstanding yes, but state immunity somehow isn't, and that comes to another point then, that it would, in my submission, be antithetical to the purposes of state immunity to say that a state is immune from the jurisdiction of the courts. And I understand there are absolute and there are restrictive doctrines of state immunity. A particular jurisdiction could have the most restrictive regime of state immunity in the world. But if there is some circumstances under its law where a foreign state is entitled to state immunity, then it's entitled to that state immunity. And to say that notwithstanding that state immunity, notwithstanding that a court could not make a salvage reward finding against it, notwithstanding that a court could not order the arrest or detention of the property, notwithstanding that a final judgment of that court could not be enforced against the state, nonetheless an executive authority could continue to detain that property, thereby forcing that state to bring proceedings of its own if it wants to get the property back, and then to say once the state does that, it's deemed to have submitted to the jurisdiction and it loses its state immunity.
How is the receiver to judge when the moment has come when a court decision awarding salvage is no longer possible. You've suggested that the limitation period of 2 years may provide the answer,
Yes.
but that's the limitation period under the Salvage Convention. And there will be states who aren't parties to the Salvage Convention who might, after a period of 25 years, regard it as possible for the salvor to get a claim against the owners. So does the receiver have to detain effectively indefinitely until the receiver is satisfied that there is no jurisdiction anywhere in the world in which it is possible that a claim to salvage might be established?
Yes, well, I hadn't said anywhere in the world, but
Well, why not? Suppose that a claim for salvage was made good in South Africa within the
Yes.
2 years in this case. That would be a determination that salvage was due, I imagine you would say, which the receiver would be bound to act on.
yes.
When I say anywhere in the world,
Yes.
I mean anywhere purporting to exercise competent jurisdiction.
Yes, yes. No, I have to admit, I would have to take instruction on that point. I can see the argument that if a claim could be brought somewhere else in the world or had been brought somewhere else in the world and might be enforceable in this jurisdiction once judgment was given, that the provisions might be applied in order to enable that to be possible. That's not the situation in this case, and I haven't come prepared to address that express question. If it would assist the court, I could delve into it. But it would follow from my submissions that, yes, at some point the receiver would, although I've given the 3 negatives that the receiver can't do, that at some point the receiver may have to make a decision as to whether any claim is possible anymore. And presumably, in practice, that would be evident from correspondence with those concerned. If the salvor couldn't satisfy the receiver that there was anything they were doing or could do, that might answer the question. And if there was something they could do and were doing, that might be a similar situation to what things were at the outset, if someone is claiming. There may be grey areas, but life is never without grey areas. But the now, another aspect of this is the practical one. My instructions are that it has not been the practice of the receiver of wreck to make salvage rewards. That the receiver may act as an impartial facilitator to see if an agreement can be reached between the salvor and the owner. But if the parties don't agree, that the matter then goes to litigation, if not arbitration, and that the office of the receiver of wreck does not have the resources or the expertise to make such decisions, particularly in a complex and high-value case such as the present. I'm told that the, section 248, subsection 2, says that the Secretary of State can appoint one or more persons to be receiver of wreck.
So sorry, I didn't catch that. Could you just repeat the section?
248, subsection 2.
Thank you.
There can be more than one receiver of wreck, but that in practice, I'm told at least since 1995, but possibly before that, I think, it's just a case of institutional memory not reaching back to the early days of merchant shipping acts, but I'm told there is one receiver of REC.
But if the Secretary so desired, Sir Nigel Teare could be appointed a receiver of REC and could be the person who dealt with claims where salvage was an issue.
Yeah, I would accept that what has been the practice to date is not an authoritative interpretation of the legislation, of course. I'm simply pointing out the practicalities that the receiver of REC has not exercised this function and has not been set up to exercise this kind of function.
Can you help me with what Mr. Richard Akins, as he then was, said in the Lusitania?
Yes, I think the simple point on that is that that was a case of unclaimed REC. And there, when it comes to what he said...
It wasn't from UK waters.
No, it wasn't from UK waters. And the issue in that case, it was about unclaimed REC. So the issue was...
Sorry, can I interrupt and can you just explain what he said? Because
Sorry.
I've seen a reference to him
Yes.
as having said something, but I have no idea what he said.
He said that the should we turn it up?
Yes.
Yes, please.
So it's Additional Authorities Bundle, tab 21, page 311. And I think the relevant page is
I think it's 320
of the
320 of the bundle, 393 of the judgment.
Yes.
Just
Now,
below E. Perhaps we'll all just remind ourselves of that short paragraph. Mr. Akins commenced his submissions. 393E of the judgment. Yes.
Now, this was a case of unclaimed REC, and I appreciate I'm giving a long introduction before coming to all the statutory provisions, but there is a statutory provision that says that the Crown is entitled to unclaimed REC. And the current legislation says that in the cases of unclaimed REC, the salvage reward is decided by the Secretary of State. In the 1894 Act, it said it was decided by the Board of Trade.
But that's only for REC from UK waters, isn't it?
Well, the issue here was
No, I mean the statutory provision. The statutory provision, which identifies that the Secretary of State can give general or specific direction as to the amount of salvage recoverable, is limited to unclaimed REC from UK waters, isn't it?
Well, certainly that's what this decision was about. And
No, because this decision wasn't about a wreck that was in UK waters,
Yes,
either at the
exactly.
time when it sank.
Exactly. So it held the Crown is not entitled to unclaimed REC that came from outside UK waters.
That was the issue in the case, wasn't it?
Yes.
Yes.
I'm sorry.
So
I was
yes.
misunderstanding.
So we have unclaimed REC from outside UK waters. It's brought into the United Kingdom. I see. Yes. Well, my submission on this was going to be at the time, the submission of the Crown, as they were referred to in the judgment, was that the Crown also had title to REC that was brought in, to unclaimed REC that was brought in from outside the UK. And therefore, this passage which was describing the then practice, I accept it says this was the practice in relation to all wreck. I'm not in a position to say exactly what the practice was in 1986. I don't think my clients have done historic research, but from a reading of this judgment, it seems that it was all about unclaimed wreck. At the time, the government position was that the Crown is entitled to unclaimed wreck even if it comes from outside the United Kingdom. In the case of unclaimed wreck, the government, the Board of Trade or the Secretary of State decides the amount of the salvage reward. So if the government says that even if it comes from outside the UK, we're entitled to the unclaimed wreck, it would follow that the government's entitled to determine the salvage reward, even if it comes from outside the UK. The court in that case said, no, that's wrong. If it comes from outside the UK, the Crown is not entitled to unclaimed wreck. Would mean it may follow that that means that the provision conferring the power on the Secretary of State to determine the salvage reward doesn't apply to unclaimed wreck from outside the UK.
Well, it plainly doesn't on its terms.
Yes, yes, but the point then is that
That's not a result of the decision in the Lusitania. That's the only sensible reading of the statutory provision.
Yes, but the point then is that where there is a power on the Secretary of State, and we would say or the receiver, to make a binding decision as to the amount of a salvage reward, that power is conferred by statute, because it has to be. I mean, the Secretary of State or the receiver cannot have that power unless it's conferred by statute. And we see in the Merchant Shipping Act, when there are powers to determine amounts of security, to determine apportionment between parties, to determine the amount of the salvage reward, that power is conferred by the legislation. Here we have an express power conferred on the Secretary of State to determine the amount of salvage rewards. It's confined to very specific circumstances. And I would submit it follows that if there was any power in the receiver of wreck to determine the amount of salvage reward, it would be stated.
I understand that submission.
Yes.
I just we came along this line because you was urging upon us the practical consequences being unattractive of the receiver having to be resourced in order to determine salvage. And quite apart from the generality of Mr. Aiken's statement here, what we've been exploring suggests that at least in some cases it has to be sufficiently funded and resourced to determine salvage.
Well, in those cases, as I say, the practical arrangements are not a binding guide as to the interpretation of the legislation. But
just thinking loud here, Dr. Staker, is it possible that the apparently broad statement between letters E and G, on page 393, is properly to be read in the context of the preceding paragraph, which very clearly is talking about unclaimed wreck?
Yes, that was my submission was that the context of that passage is all about unclaimed wreck. If we go back to the previous page, page 319 of the bundle, the last paragraph starting on that page, we can see that this passage is all about unclaimed wreck. So we start on Mr. MacDonald's contentions that if the Crown is entitled to all unclaimed wreck, and it goes on. And then on page 320, the paragraph preceding the paragraph we've been looking at, it says, whereas it doesn't cause any surprise that the Crown or the State might assert a right to unclaimed property found within its boundaries, including its territorial sea, an assertion of such a right over property outside its boundaries, possibly on the other side of the world, is something that ought to be clearly stated in the Act. Now that in my submission is the context of the passage that is being looked at.
So it's a description of the practical consequences of applying Section 525, which applies to unclaimed wreck within territorial waters.
Yes, and if the Crown's position at that time was that it extended to wreck found outside those waters, they may in practice have been applying it to unclaimed wreck from outside the UK at that time.
And if it's unclaimed, there isn't a dispute.
No, if it's unclaimed, there's no dispute between the owner and the salvor. Well, I think yes, I think the introduction has basically been presented. So I will take you to the legislative provisions.
Just before you do so, can I ask one other question? The silver in this case is it in the intervener's case wreck?
Well, the interveners haven't addressed that question.
Well, why is it wreck?
Well, I mean, it must be wreck because it's being held to the order of the receiver of wreck. So the receiver clearly is proceeding on that basis.
I'm afraid
the
fact that it has been labelled wreck does not make it so. It's not. This isn't. This is an inquiry which has some sort of ramifications.
Yes.
Wreck is defined in the Act as including derelict, flotsam, jetsam, and so on. It isn't any of the flotsam, jetsam, or lagan. It can only be wreck if it's derelict, presumably.
I haven't come today prepared to address that point. I would be reluctant to do so without taking further instruction.
Let me just tell you what my my inquiry is aimed at understanding, and it may well be that Mr. Smith and Mr. Hofmeyr will want to address this. As I understand the concept of wreck, which is overlaid with a good deal of historical authority, the silver can only have been wreck in this case if it was derelict, and derelict applies to vessels, and it seems to apply to cargoes as well, and certainly in relation to vessels, it's defined as something where the vessel has been abandoned by the owners with an intention of abandoning it, including no hope of recovery. And parenthetically, I would say, well, in cases of wreck vessels, that might mean that what was a wreck in 1942 wouldn't necessarily be considered a wreck now, because hope of recovery may be influenced by the improvement in salvage techniques. But however that may be, in relation to vessels, as I understand the law, derelict, which was what made a vessel a wreck, depended upon the state of mind of the owners when the vessel was abandoned. So far as cargo is concerned, I'm not myself clear whether cargo becomes derelict, which it can, if it's on board a derelict vessel simply by virtue of the ship owner having that state of mind, the intention to abandon, or whether what matters in order to make cargo derelict is the state of mind of the cargo owner. And if, in order to be wreck in this case, the silver had to be derelict, and if that had to involve an intention on the part of the cargo owners, that's to say the Republic of South Africa, to abandon the cargo without hope of any hope of recovering it, well then that might have some bearing on the other issues we have to decide. And that's why I welcome a little assistance on the law. Obviously you're not in a position to give it at the moment, but certainly from somebody, as to what makes cargo derelict, and in particular whether it's the state of mind of the ship owner or the state of mind of the cargo owner, or whether in this case the cargo is derelict, is wrecked for some other reason than having become derelict. I don't think it.
I think all I can say is that's not one of the issues on which the interveners have sought to intervene. If it would assist the court, then, well, of course, those who instruct me will understand and it would assist the court. But then the court would guide the interveners as to what the best way of providing that assistance might be.
Let's see what assistance Mr. Hofmeyr and Mr. Smith can give us on that, and take it from there.
Yes. Okay, we come then to the statutory provisions. They are Part 9 of the Merchant Shipping Act, 1995. Part 9 begins at page 64 in the bundle. So the Merchant Shipping Act starts at page 64, and Part 9 begins on page 70. We will.
Sorry, I'm sorry to keep interrupting.
Sorry, additional authorities.
I'm sorry to keep interrupting. There is one other
Yes.
aspect that we have to keep in mind, which is that the issue in the case, strictly speaking, involves an interpretation of provisions of the 1978 State Immunity Act.
Yes.
And one is looking at the powers of the receiver of rec through the lens of whether the draftsman in 1978 had in mind that immunity was only governed by the Section 10 of that Act, or whether it might also, in cases of rec, have to take into account the ability to recover rec under the provisions of the Merchant Shipping Act. So strictly speaking, where we ought to be concerned with the provisions of the predecessor to the 1995 Act, which I think is the 1894 Act in this respect. But I quite understand why you're directing your submissions to the 1995 Act, and you've been invited to do so, but perhaps you would identify if at any stage there is any significant difference in what is in Part 9 of this Act from what was in the 1894 Act.
Well, I will be referring to some provisions of the 1894.
I've seen that, but can we take it that where you don't do so, these provisions replicate what was in the 1894 Act?
I'm not sure it would be safe to make that assumption. I've made the comparisons relevant to my submissions, but if we take broader questions, then I would hesitate to give an off-the-cuff answer. Perhaps if we see which provisions we do look at.
We're going to look at pretty much all of them, aren't we?
Of Part 9 of the 1995 Act.
Yeah.
The 1894 fewer. But if we start at page 70 with the 1995 Act, Part 9, we see Part 9 is called Salvage and Wreck. It deals with both salvage and wreck. We have Chapter 1 dealing with salvage, sections 224 to 230. We have Chapter 2 that deals with wreck. And then we have a Chapter 3 starting at section 248, which is called supplemental. And that contains provisions that relate to both chapters 1 and 2. The provisions relevant for present purposes, if I just take them in order, we start at chapter 1 at section 224. So we're now in the chapter dealing with salvage. We have 224 subsection 1. That provides that the Salvage Convention has the force of law, and the Salvage Convention is in Schedule 11, Part 1. And then we have 224.2, which says that supplementary provisions relating to the Salvage Convention also have the force of law, and they're in Schedule 11, Part 2. We go then over the page to section 225. We have a provision, valuation of property by the receiver.
So just pausing on the. Sorry, I should have asked you this question sooner. Section 224 basically incorporates the Salvage Convention into domestic law, and Article 25 of the Salvage Convention, which is on page 109 of the Authorities Bundle, does deal with state-owned cargoes and proceedings in rem, doesn't it?
Yes, the interveners don't intervene on the issue of state immunity, as
No.
I've said. It's my skeleton does at the very end contain a very brief submission, simply because it's part of the Merchant Shipping Act. I have provided in the authorities bundle a extract from the Travaux Préparatoires to the Salvage Convention that seemed to indicate that the intention of that provision was not to provide any greater immunity than already existed under the domestic law of all states becoming parties to the convention.
Oh.
Yes, and my lady may be unaware that Mr. Smith on the last occasion made clear that if there were no immunity under the Act, he wasn't seeking to say there was any greater immunity by virtue of Article 25.
Yes.
Yeah. Well, that's very helpful. I mean, I didn't know that because I haven't had time to read the entire transcript of day one of the hearing. That's very helpful. Thank you.
Okay, 225, valuation of property. So where there is a dispute as to salvage, the receiver can appoint a valuer to value the property. And then in subsection 3, it says that the valuation shall be admissible in evidence in any subsequent proceedings. Not conclusive language, but any subsequent proceedings, I would submit, implies court proceedings, and if it meant that the receiver could determine the salvage reward, it might have said something like, shall be taken into account by the receiver when determining.
But also the phrase shall be admissible in evidence rather has a flavour of court proceedings, doesn't it?
Yes.
But the fact that it's admissible in court proceedings doesn't mean it's not something which may be of benefit to the receiver. It is a power which is conferred on the receiver, and therefore one would prima facie imagine that it is intended to be, the valuation is intended to be something which serves a useful function for the receiver, not exclusively in subsequent court proceedings.
Yeah, I accept a lot of these provisions. What I submit in relation to them is not a conclusive answer to the question. It's these many provisions together. One gets the flavour. First of all, when statutory powers are conferred, they're conferred expressly. Often they're quite precise. They're confined to certain situations. They're confined to amounts of less than £5,000. We say that shows that if the receiver had a certain power, it would be there expressly. Another general submission I make is that many of the provisions assume, some of them assume it much more strongly or imply it, or perhaps necessarily imply it. Others are simply consistent with it or have the vibe about it. But give the flavour that salvage disputes will be determined by a court.
Well, I understand your point that we've got to look at all these provisions and
Yes.
no one may be determinative, but if we look at them one by one, Section 225 does envisage that a valuation of the property is to be of use to the receiver in the exercise of the receiver's functions. Otherwise, there would be absolutely no point in giving a power to the receiver
But he hasn't
to
also
procure a valuation, and the fact that it's also admissible in subsequent court proceedings doesn't undermine the fact that prima facie one expects Section 225 to be addressed to the receiver being able to do something with the property valuation which it's given the power to commission. And if that be right, what is there apart from determination of salvage that would be a use to which the receiver would put a valuation of the property?
Yes, well, I have said before, the receiver does in practice exercise the function of neutral facilitator. And certainly that provision would be consistent with that function. If the parties are having difficulty agreeing on a salvage reward, it says here that the receiver may, on the application of either party, that would seem consistent with that kind of function.
Thank you.
So 226, this is one of the three key provisions in the case. We've discussed this already. But it applies specifically to wreck in subsection 1, paragraph B. And that's relevant to a general submission I make that Chapter 2, dealing with wreck, is not a special regime for wreck, and that the provisions in Chapter 1 that refer to wreck are referring to Chapter 2, and the references in Chapter 2 to salvage are a reference to Chapter 1. The part as a whole is called salvage and wreck. The part as a whole needs to be read together. Um, 226 subsection 3. The wreck can be released on payment of security, and it says that if the claim is for less than £5,000, the security must be to the receiver's satisfaction. If it's more than £5,000, it must be to the satisfaction of the court.
Well, that's one reading of it. An alternative reading is that whatever the amount, he can release it if security is given to his satisfaction, or in cases where it exceeds £5,000, that's a matter that can be raised with the court, but the court's not going to be concerned with questions of security for property of less than £5,000.
Sorry, I'm not quite sure I
So
that.
A covers all cases. A is not limited to plus or minus £5,000. The receiver can release any property if security is given to his satisfaction, full stop. And then the alternative is that he can also release it if security is given to the satisfaction of the court, which is a matter that can be raised by the court where the claim for salvage exceeds £5,000. Is that a way in which that subsection could be read?
I can accept that grammatically that would be a possible reading. I can only say the intervener's submission is that that's not the reading, and again...
But is there any purposive construction that would make that an uncommercial one or an improbable one?
Well, presumably when very large amounts are involved, the parties would feel entitled to have this looked at by a court rather than a senior executive officer.
Well, let's just explore that. Suppose that the owner provides a first-class bank guarantee payable on demand against an award or on agreement, and it's blindingly obvious to the receiver of wreck that that's good enough to cover whatever the value of this cargo is, or indeed you might have had it valued. Why should the parties be forced to go to court and waive the bank guarantee under the nose of a judge and say, here is a first-class bank guarantee, but the receiver of wreck says that he's got no power to accept that that's satisfactory?
It's possible I would need to take instruction on that,
Yeah.
but
you see the practical common
Yes,
sense
yes.
of my lord's reading.
yes, I imagine, I don't say this because I think I would take instruction on it. I imagine if there was no dispute between the parties and both parties accepted it, that it may not have to go to a court. The issue is when there is these provisions about when the parties are in dispute. If it's a small matter, less than £5,000, it can be dealt with administratively by the receiver. If it's a large amount, it would go to a court. That would be the purpose of reading. And back in subsection 2, again, we have the provision that the receiver is to detain the property until either payment is made for salvage or process is issued for the arrest and detention of the property by the court. Now again, the question arises, why would you apply to a court for the arrest and detention of the property if the receiver otherwise had the power to detain and had the power to determine the salvage reward?
Well, this is just dealing with detention, isn't it?
This is just dealing with detention.
This is, as far as the court is concerned, process being issued for arrest or detention of property.
Yes.
It's not process issued for determination of the amount of salvage.
No. So again, this is not a provision that I say is conclusive as to the submission, but the assumption that it conveys is that the receiver detains the property and detains it until either the salvage is paid, which might be done if the parties agree, or else court proceedings are begun. The reason it talks about arrest or detention by the court is because this provision is all about arrest or detention. It's under arrest by the receiver of rec. The receiver keeps it under detention until it becomes subject to detention by the court.
I understand that. I'm just wondering why you're suggesting that the reference to process in the court casts any light on whether there have to be court proceedings for the determination of salvage, when this is all about detention. And
because if the receiver has the power to detain, and if the receiver had the power to determine the amount of the salvage reward, why would a court have to get involved at all?
Well, it may well be that the receiver decides that they don't want to detain it because there's a dispute about whether or not there's a proper claim. So the person who's claiming salvage says, right, well, I'm going to start proceedings in rem. We'll get the court to seize the property.
the process, the detention must last. The obligation of the receiver to detain must continue beyond the mere issue of process, mustn't it?
Again,
In
yes.
practical terms,
again,
it would be bizarre if the receiver had to release
This is
simply because an as yet undecided court claim for detention had been brought.
yes. This is not the first provision we've looked at today where we said it can't be read literally.
Yeah.
And in the real world, it has a purpose, and yes, we look at it in that purposive way.
I think I'm right in saying that there was an absolutely equivalent provision in the 1894 Act, wasn't there?
I'm sorry?
I said I think I'm right in saying, I've had a quick look at the 1894 Act, that there is an absolutely equivalent provision in the 1894 Act. I can't remember which one.
Sorry,
it is.
it's
518 and 522.
I'm told 518 and 522, I thank my friend. Yes, so 518 is similar to 226. Oh, 522 is the provision where the receiver can sell property, which is another provision of the 1995 Act I was coming to.
Well, as I speak for myself, for reasons I've given, I would like to be told if there isn't an equivalent provision of any of these in the 1894 Act. Because if there isn't, the draftsman can't have had them in mind when the 1978 Act was enacted.
Yes. Well, I'm yes. Sorry, my question's whether I can assist on that point or whether the other parties will be dealing with
Well,
that.
certainly by the end of the hearing, I'd like somebody
Yes,
to give me the answer to that question.
Yes. 227, I submit, is perhaps one that more strongly than the others indicates that the receiver does not make salvage or determinations of salvage reward. I use the word rewards because that's the expression used in the convention. So the receiver can sell property and out of the proceeds pay the salvage and give net proceeds to the owner in 3 cases. One is where the amount is not disputed, so there's an agreement between the parties, and the other is, well, a court has determined the matter and there's no appeal. And the other is, it's been determined by a court and there is a right of appeal, but the time limit for appealing has expired. And I submit that's the provision that is perhaps the clearest, because if the receiver had the power to determine the amount of the reward, it would be expected to say that the receiver could also do that if the receiver has determined the amount of the reward and it hasn't been paid, then the receiver can sell the property and do the same thing. And again,
sorry, I missed that last point. Say that again.
it provides a power where the salvage reward has been finally determined by a court, but not paid by the owner, for the receiver to sell the property and out of the proceeds pay the salvage reward and then pass on any net proceeds to the owner. If the receiver had the power to determine the amount of the salvage reward, it's to be expected that the provision would also say that it applies in circumstances where the receiver has determined the amount of the salvage reward.
Well, would that be a case which would come within A, where the amount could no longer be described as being disputed?
Well, again, this would be implying powers that are not given. So I've made that one submission. Where powers are conferred, they're conferred expressly. We have a lot of provisions conferring a lot of different powers. They're quite precisely confined that in these particular circumstances there is a power to do this or that. To say that in all circumstances the receiver has a power to determine the salvage reward, I would submit is very hard to derive that from the wording of the legislation, where absolutely nothing is said on the subject at all. It would have to be somehow implied into the wording of Part 9 as a whole that the receiver must have this power. And my submission is everything speaks against the receiver having it. It's all this talk about the receiver, the Secretary of State, having specific powers about things being determined by a court, and nothing about a general power of the receiver to determine salvage rewards. The nearest that that we come to that is, well, I think on the submission of the appellant, it must be the case that they rely on section 2391, which says simply on paying the salvage.
Due.
On paying salvage due. Now, I would submit, in the context of this legislation that contains so many provisions conferring so many precise powers, I submit those words can't, well, I've made this submission already, I'm sorry I'm repeating myself, but it can't be read as creating a substantive right to salvage that is conferred by section 224, which gives the force of law to the Salvage Convention. And it would be reading an awful lot into that provision to say that this creates a mechanism by which the receiver has a power to make binding decisions as to salvage rewards.
And I suppose you rely on 2284 as a specific example of an express power to make a decision which is conferred on the receiver.
Yes.
And it's a wide decision-making power on such evidence and in such shares and proportions as he thinks fit.
Yes.
And
Now,
that's all done expressly.
yes. So, I mean, another point that could be made there. Here is an express power conferring on the receiver the ability to make decisions as to apportionment of salvage rewards after the salvage reward has already been finally determined. So that implies that the receiver doesn't have the power to determine the salvage reward, since otherwise one would expect that to be expressly stated as well. But also, even the power to apportion is limited to cases where the amount in question is £5,000 or less. And that very much speaks against the conclusion that the receiver has a general power to make salvage rewards, regardless of the amount in question.
It says nothing about whether you've got a power to determine it, because it presupposes that somebody, and we don't know who, has already determined the aggregate amount of salvage. So there has been a determination before
Yes.
Section 228 kicks in.
Yes.
And then after such determination, because there's still a dispute between various claimants as to who gets what amongst the amount that's under £5,000, the receiver has an express power to decide who gets what. Your point is, well, it's an express power that's conferred on the receiver in specified circumstances, and there's nothing equivalent that says that they get the opportunity to do the determination. It just begs the question of who does the determination, doesn't it? Section 228.
Yeah, which is part of my submission that all of these provisions are read together as a whole.
I mean, might one get some clue, a general contextual clue from Section 2, the hierarchy in Section 227, subsection 2?
Yes. Yes, exactly. It's precisely my point. Also, 226 that I referred to before, again, which talks about court proceedings being instituted. Another is, in fact, the Salvage Convention itself, because the Salvage Convention in Article 2 says that it applies where judicial or arbitration proceedings are conducted in a state that's party to the convention.
Sorry, which provision is that?
If we go to the Salvage Convention, on page 103 of the bundle,
Thank you.
Article 2 says, this convention shall apply whenever judicial or arbitral proceedings relating to matters dealt with this convention are brought in a state party. So if proceedings are brought in a court, or there are arbitration proceedings, the convention applies. If the receiver had the power to determine salvage rewards, on its reading the convention wouldn't apply, which would lead to the question, if the convention is the part of the act that creates the substantive right to salvage, what would be the basis of a substantive right to salvage determined by the receiver?
But it also slightly raises the question of what's the point of incorporating the convention in domestic law if you'll then, by the provisions of the Merchant Shipping Act interpreted in a particular way, creating a backdoor through which the convention doesn't apply, because on one argument the receiver is not a judicial authority and proceedings in front of the receiver are not judicial. I'm not saying I agree with that proposition, but that's an argument, isn't it?
Yes, but the point is that if the receiver had this power, it would be made express. If we go on to page 111 of the bundle, we're now looking at Part 2 of Schedule 11. These are the additional provisions that apply in relation to the convention.
I was looking at it in
Page
a different bundle. So which bundle are we in?
So the additional authorities bundle.
Thank you. I'm sorry, I was looking at it elsewhere, but without the
No, this is part 2 of Schedule 11, which are the additional provisions applying in relation to the convention. Paragraph 4, it says, in fixing a reward under Article 13 and assessing special compensation under Article 14, the court or arbitrator is under no duty to, the provision is dealing with the duty of the court or arbitrator when applying the convention. And again, if the receiver had the power to determine salvage rewards, it's to be expected it would say the court or the arbitrator or the receiver. And then in the conventions, well, of course, because it applies in judicial or arbitration proceedings, it contains references to judicial proceedings and to the tribunal. And paragraph 6 of these additional provisions say that judicial proceedings are references to, in England and Wales, the High Court or the County Court, and tribunal having jurisdiction as far as it refers to judicial proceedings are construed accordingly. So again, I submit it assumes that unless the matter goes to arbitration, it is determined by a court. I am conscious of the time. I could take the court through every single one of the provisions that I propose to refer to, but it's perhaps unnecessary. The court,
well, you've identified a number of the others in your skeleton argument.
Yeah, exactly. They're in my skeleton. That you can see.
If you've taken us to the ones you think are the most important ones,
Yes.
We won't ignore the others.
Yes.
My lord and my ladies, just for your own note at this stage, of course, the salvage convention was 1989. And so if one was looking for differences between the legislation in place in 1978 and now, then that wouldn't have been part of the legislation.
I will then take you to the provisions of the 1894 Act.
Well, section 553 is your main point, isn't it?
Well, there's
That's
a
the
couple
mirror
of points.
image. I've just checked the language. It's the mirror image of section 227.
Yes, so we have 552 is the equivalent of section 226 in the 1995 Act. And 521 is the equivalent of 239. Then
Sorry, 531, do you say?
521.
521.
Then I was going to take you to 547. Subsection 1 of 547 said disputes as to the amount of salvage. And then it goes on to mention specifically wreck. And it says, if not settled by agreement, arbitration, or otherwise, is to be determined, and then there is a summary procedure for determination in the county court. And in subsection 2 says, subject to that, it shall be determined in the High Court. That, I submit, is an indication that the provisions, that the main provisions we've been looking at in the 1995 Act that have their equivalents in the 1894 Act. In 1894, it was not considered inconsistent with those to have an express provision that's saying disputes will be either agreed or determined by a court.
So this seems to envisage 4 possibilities of settlement. 1, agreement.
Yes.
2, arbitration. 3, otherwise. And 4, in court proceedings. What's category 3? What does or otherwise cover?
I suppose the question would be, can one read into the word otherwise that the receiver had the power to make determinations of arbitration?
Which itself may be informed by whether it could, what else could it be?
Well, there may be theoretical possibilities. It may be determined otherwise by the fact that a limitations period has expired. It might be determined otherwise because the claim has been extinguished by force of law somehow.
Well, this is dealing with questions of determination, as indeed the side note shows, determination of disputes.
Yes.
It presupposes there's a dispute which needs to be determined, and it's identifying who can determine it.
Yes. And it
So
doesn't
otherwise must be contemplating that something other than agreement, arbitration or court proceedings is capable of determining a dispute.
I wouldn't have thought an extinction of the limitation period is really apposite to describe that.
My submission would be that in circumstances where statutory powers are conferred expressly when they're conferred, it's very difficult to see how you could read in a power for the receiver to determine in a binding way arbitration awards regardless of the amount of the claim through the use of the word otherwise in a provision that says it has to be by agreement, arbitration, or a court decision.
Yeah. Well, I think, I mean, obviously we've got to read all this.
Yes.
Read all this together. But I think the high point of the case that's put against you is that against the background of it being the function of the Secretary of State to supervise all these matters, Section 239 of the 1995 Act, 521 of this Act, requires the receiver to make a decision as to whether to release the wreck or the proceeds, and the conditions under which it can and must do so include a condition as to whether salvage is due. And if the receiver is to perform that function, the receiver must decide whether salvage is due. That's a statutory function placed upon the receiver. And only the receiver can can satisfy himself of that. He may satisfy himself because a court has already so decided, but it's still his function only to release where he considers that salvage is due. I think that's the high point of the case that's put against you.
Well, I think I've already made the submissions that I have to make in relation to that. What can be said is if a reward can only be determined by a court, and if the purpose of the detention is to ensure that once a court gives its decision, that it will be capable of being enforced because the wreck will have been detained by the receiver of wreck in the meantime. It would seem inconsistent with that for the receiver to release the wreck in the meantime on the basis that even though court proceedings are ongoing, the receiver is quite satisfied. And if a court determined the matter, it would seem inconsistent. It would be difficult to see on what principled basis it could say the court has decided that there's no entitlement to a salvage reward, or the salvage reward will be this, for the receiver to say, well, I'm not satisfied with that, so I'm not releasing the wreck.
You might or might not, but that doesn't answer whether it's whether you started your submission by if it can only be decided by the court.
Yeah.
which assumes that which you're setting out to establish.
But,
would it, just in practical terms, I mean, would it be very surprising if Sir Nigel Teare were the receiver and determined a salvage award, and whether salvage was due for the purposes of retention or release, and like any other public law function, that was susceptible to judicial review, and the court would review or not, as the case may be.
Well, I've made the submissions that I've made. You've said that I'm seeking to assume what it is I'm trying to prove, but in fact I am trying to prove what I'm trying to prove through references to these varied versions of the legislation. So my submission is there simply is no power.
Well, I think that the last point that you made, although it was prefaced in the way that my lord said, it doesn't deprive it of its force, because what you're saying is that if the receiver's got the power to make a determination, it would be a bit strange if the receiver decided that there was a right to salvage and what the award would be, whilst the parties are arguing it out in court. So the idea of if there's undoubtedly a power in the court to determine it, but the parties are still having a fight about it, and the receiver then decides to go off and determine it for himself. And I see the force of that.
Well, that might be judicially reviewable.
That might be judicially reviewable,
or it might be on process grounds.
Yes.
Yes. Another more general submission I would make is we are talking about the powers and duties of the receiver and the Secretary of State that would apply in all circumstances.
Yes.
And in this case, the thinking is being coloured by the fact that the owner is a state claiming state immunity. But whatever the powers and duties are, they would apply in all cases. There's no suggestion that if the receiver has a certain power, it would only be applied where there's a state claiming state immunity. No. And I would submit that it's wrong to seek to interpret the Act in a certain way based on concerns about state immunity. And one of those reasons, it's again given in my skeleton, is that although in this country there may be a view that something should fall within restrictive exceptions to state immunity, and that would be a matter for a court to decide if salvage proceedings are brought. But as long as there are areas where a state is entitled to immunity, it would be wrong to seek to interpret the Merchant Shipping Act in a way that got around or undermined that. And there is a view expressed that the claimant would somehow be left without a remedy if something wasn't possible under the Merchant Shipping Act. But the philosophy of state immunity is not to deprive claimants of their right to make claims against states. The philosophy is to respect the sovereign right of a state to have certain matters dealt with within its own legal system. The state can say, this is a matter sufficiently falling within my area of sovereignty. If someone's going to bring a claim, they bring it under our legal system. I don't know that it's been explored what remedies might or might not exist in South Africa in this case. I'm not in a position to say anything, but I accept in some states there may be no remedy. There are large variations in legal regimes around the world.
The problem for the claimant, sorry to interrupt you, the problem for the claimants is the limitation periods expire. So the consequence is that if a salvor who's otherwise entitled to a salvage award brings the action for salvage in the wrong place, the state basically escapes.
Yeah,
and now, that may well be the natural consequence of all of this. It may well be that it's the consequence for the claimant that he's had the misfortune to bring the action in the wrong jurisdiction, and tough luck, because hard cases make bad law, and that may well be right. But that's the concomitant of all of this. But you're quite right that one shouldn't start to apply an elastic interpretation to provisions of the statute that have been going since the 19th century at least, in order to get round a difficult case.
So that's the general submission.
Yeah.
Yes, that state immunity may create problems, but the solution shouldn't be
tailored to it.
Yes. And the other general submission is, again, if the receiver had a general power to fix salvage rewards, presumably those decisions of the receiver would be amenable to judicial review. That would mean that where there is a dispute between the owner and the salvor as to the amount of the salvage reward, instead of those two parties taking the matter to the Admiralty Court to be dealt with as a proceedings between the two of them, it would be decided by the receiver, and then one or both parties, if they're dissatisfied, would go to the administrative court.
Where you could get the Admiralty judge sitting, as you did in the case of Knight.
But we still have a situation then where instead of two parties, and essentially it's a dispute between two parties, instead of two we have three. The main defendant is there at public expense, expending public resources, dealing with a case that is really a dispute between the two other parties.
Well, you often get public law cases in which the decision maker takes a neutral stance and the interested parties fight it out. One could see one might have the same here.
Well, the question is whether that's the way to go about it. And then the next point, of course, then is that the focus of the proceedings would be on the decision-making process and public law principles.
Yes.
Rather than what's really in dispute, which is between the two parties, what is their entitlement under the Salvage Convention principles to a salvage reward.
Yeah.
The obvious place to bring it is in the Admiralty Court. And I would submit a rather obvious place not to bring it would be the Administrative Court. So again, well, in fact, yes. Again, I say to avoid a problem in one specific narrow situation, it would be creating a solution that would apply to the generality of cases, not just those where we have a state claiming state immunity, and would lead to a result of general application that is not particularly convenient or appropriate.
I understand that. Salvage is a slightly curious creature whose historical justification is an award of what is fair, and it isn't a quantum merit, it has all sorts of provisions.
Yes.
And it might therefore be said to be perhaps less unsuitable to administrative decision subject to judicial review than what might be described as a hard-edged question of law, where the courts are going to decide what the rights are.
But there are principles in the Salvage Convention of how to matters to take into account and so forth. So in the Admiralty Court, the court would say, as a matter of substantive law, let's apply the Salvage Convention, let's apply the principles, let's look at the evidence, let's make a decision. The administrative court would not be doing that. It would be, what did the decision maker do? Was that reasonable?
Well, it would be looking at whether the decision maker took into account all the relevant considerations. That would be, if he didn't, that would be a public law ground of review.
Yes.
It would simply be the result.
But
In which there would be more latitude, as it were,
yes,
in that the application of those principles might reasonably result in a range of different numbers, and provided the receiver was within that range, there would be no review, even if a court would come to a different number.
Yes.
That's the point you're making.
Well, yes, and in the administrative court, at the end of the day, if there are no errors of law in the decision of the receiver of REC, it would mean that the decision as to the amount of the salvage reward would be taken by a senior executive officer in the civil service.
Well, not necessarily. And not necessarily without advice. We've identified that the receiver could be appointed as someone who's very experienced in these areas. Someone who's not experienced could commission the opinion of a silk experienced in these matters to advise him or her. Speaking for myself, I'm not sure the fact that at the moment the receiver is a functionary, I don't mean that in a derogatory term, but is a functionary in a small department of the Department of Transport is really going to help us one way or another with answering the question, is it?
Well, I have perhaps assisted the court to the extent I can. I am also conscious of the time because I know that the parties
before you
have
finish,
much-
Dr. Stake, could I ask you two questions? You might not be able to help on them, but let's see. Tab 6 is the Supreme Court Act as it then was in 1981, Section 20. So this is an earlier version of the provision conferring jurisdiction on the Admiralty jurisdiction on the High Court. I think the current provision is almost exactly the same. Do you have any submissions to make about the proviso to subsection 7? I just wonder, on the face of it, the Admiralty jurisdiction of the High Court is extremely wide. Is it in any relevant way cut down by that proviso? Maybe you haven't thought about this question, and if you haven't, then just say so.
Well, it's not a question I came prepared to answer.
No, all right, well, that's fair enough.
It says it doesn't extend the cases under the Merchant Shipping Act. It also doesn't purport to restrict them. So, in a sense, it simply asks the questions.
What I was really wondering was whether you can point us to any provisions in the Act 1894 to 79 which suggest that the receiver got power to decide salvage, but it may be that, you just haven't thought about it.
No, but it would mean on its terms that if the receiver didn't have the power, this wouldn't be.
This is confined to subsection 7.
Yes.
I'm not quite sure myself what the scope of subsection 7 is. It starts with ships and aircraft.
Well, I think it's saying that the whole section has a very wide application, isn't it? Subsection 7. All ships or aircraft, whether British or not, the registered or not, and so on. All claims, wherever arising.
Does that mean all claims full stop? In which case, I'm not sure you need it.
Yes. But the
it's the preceding provisions of the section apply to all claims, and subsection 2 defines what claims are within the remit of the section.
And subparagraph J, any claim in the nature of salvage.
Yes. But it's
All I'm trying to explore is whether you have any submissions to make about whether there's anything in the Merchant Shipping Act that cuts down the apparently wide jurisdiction conferred by this provision and its successor.
Oh, I see. No, the short answer is no. I'd have to think about it.
Okay, that's very fair. Thank you.
If I can't assist further.
Oh, sorry, I'm sorry to be
Oh, sorry,
annoying. I've got another question, please. We've got the definition. I had it a second ago and I can't find it now. Definition in the State Immunity Act of court or tribunal. It's somewhere near there.
Tab
Sorry,
5,
it's
page 40, yeah.
tab 5. So section 22 subsection 1, in this act, court includes any tribunal or body exercising judicial functions. Just assume for a moment your submissions about the powers of the receiver are wrong, and the power does have, the receiver does have power to decide whether salvage is due, and if so, the amount. Would the receiver be exercising a judicial function in doing that, or an administrative function? I mean, if you're not ready to, if you haven't thought about
yes.
it.
No. Again, I haven't thought about it. We've been talking about proceedings in the administrative court, but that is perhaps
No, that's a
answer to the
different. That's a different question
Yes,
altogether.
So no, I haven't.
No, if you haven't thought about it, don't worry. All right, thank you. That's very helpful.
So those are.
Right.
Sorry, those are my submissions, unless I can assist further. Thank you.
No, that's fine.
Thank you very much.
May it please my lord, my ladies, if I can give a little roadmap for my submissions, first of all. I propose, with the court's leave, not to recap anything I said at the last hearing, but in order to contextualise what I'm going to say, I am going to have, if I may, a brief review of our position on the points that were covered last time, because that puts into context, as I said, the points I want to make on the new points. I'm then going to deal with the question of whether section 10.4 applies to REC at all, because we consider that is the first of the questions that need to be dealt with. And then move on to deal with the other questions arising, not by reference to the specific issues, but by reference to the three questions as my learned friend and I have defined them in our skeleton argument by my learned friend Mr. Hoffmeyer, QC. So essentially, that is whether the receiver of REC has power to determine salvage, whether a party in the position of my clients can insist on cargo being handed over in any event, or sorry, the silver being handed over in any event. And then I'm going to come on right at the end to deal with the point that has just been raised, essentially as to whether, if the receiver has power, concepts of state immunity affect the exercise of that power and the receiver's ability to exercise that. So, starting, if I may, with an overview, our original application in the Admiralty Court was based on the assertion that we were immune under Section 1 of the State Immunity Act, alternatively Section 13.2b, alternatively Article 25 of the Salvage Convention. In the event Section 13.2b did not arise because there has been no attempt to arrest the silver and proceed down that route, so we only have proceedings in REC. we are immune under Section 1 unless one of the exceptions set out in the Act apply, and I think it's common ground that the only potentially relevant exception is Section 10(4), dealing with claims in rem and also in personam, but for today's purposes relevantly in rem. We accept that if the combined effect of Sections 1 and 10(4) is to provide an immunity that goes further than would be provided under generally accepted principles of customary international law, that would be a disproportionate interference with claimants' rights under the Human Rights Act. But, importantly, the Act is intended to, and we submit does, give effect to the restrictive theory of state immunity, which is, we submit, the only generally accepted principle of customary international law in this field. In fact, English law, particularly in relation to claims in rem, applied the restrictive theory long before the State Immunity Act. And the starting point is the Parliament Belge. I don't propose to turn up any of the cases I'm going to briefly refer to unless it would assist my Lady Justice Elisabeth Laing, but for us to look at them today.
Well, don't worry unless I shout.
I'm grateful for
Thank
the
you.
indication. But the Parliament Belge, even though the head note suggested that it supported the absolute approach to state immunity, in fact it applied the restrictive theory. And one can see that for my lady's note in due course from from pages 51, 55 and 56. And in fact, Lord Sumption in Benkarbouche specifically pointed out that Parliament Belge had been effectively misunderstood and was a restrictive theory case. And that's pages paragraphs 43 and 44 of the judgment. Next was the decision of or the advice of the Privy Council and the Philippine Admiral, which is tab 6 of the original authorities bundle, in which the restrictive theory was applied to an action in rem against a ship which was being used for purely trading purposes, held not immune, but also held that the writ set aside. And next, in the list of 4 cases I'm going to refer to, Trentex, which was tab 7 of the authorities bundle, page 110, applying the restrictive theory even more widely than simply to an admiralty claim. And then finally, the Premier Congreso del Partido, House of Lords decision of authorities bundle 9, authorities tab 9, the original authorities bundle, page 176. And if I can just highlight 2 quotes from that judgment. Lord Wilberforce, whether the state can claim immunity depends on an examination of those acts in respect of which the claim, i.e. the claimant's claim, is asserted. The question is whether the acts which give rise to the alleged cause of action were done in the context of a trading relationship. That's at page 199. And then Lord Bridge, where a sovereign state voluntarily assumes a purely private law obligation, it cannot, when that obligation is sought to be enforced against it, claim sovereign immunity. Page 210. And we submit that applying these cases, in other words, the restrictive theory without any gloss from the Act, we are immune, because the claim is not to enforce an obligation of a private law or commercial nature, voluntarily undertaken by the Republic or its predecessor entitled the Union Government. It is a claim based on Article 12 of the Salvage Convention, and that will be an important point to have in mind when we come on to look at issues of immunity in relation to any jurisdiction the receiver of wreck may have. and the Salvage Convention is at tab 3 of the authorities bundle, as well as in the supplemental authorities bundle in the rather longer core. And so the claim is not for any kind of monetary loss caused by breach of any obligation on the part of the Republic, still less any commercial obligation. And that, if one skips forwards in the cases, is language which I've taken from the judgment of this court, Mr. Justice Popplewell, Lord Justice Popplewell and others in the prestige numbers 3 and 4, where the question was that there was a breach of an obligation by Spain in that case, giving rise to monetary losses.
Would it follow from that, Mr. Smith, that if, I suppose we're not dealing with a cargo of silver bullion that's going to be used for smelting for coinage, but if the state put a non-perishable cargo on board a merchant ship to take it from A to B with the purpose of selling it commercially, and the ship is torpedoed by the Japanese and ends up at the bottom of the ocean, and 40 years later some enterprising salvor brings it up and declares it to the receiver of wreck, you'd still be able to claim state immunity, because notwithstanding that the venture's purely commercial, the salvage is not. Because it seems to me that that is the necessary concomitant of the position that your clients are adopting.
My lady, can I take that in 2 parts? Firstly, by reference to the cases I've just referred to, and then by reference to the Act. By reference to the cases I've just referred to, the claim, the cause of action that Salvor found itself on under Article 12 does not have, we would submit, a sufficient relationship or nexus with the original commercial transaction, of which there would have been 2. One between my client and, well, perhaps 3. One between my client and the person from whom it bought the cargo. One between my client and the owner of the ship. And one between my client and the person to whom it was going to sell the cargo. But the claim to salvage is not, other than by way of background, which we would suggest is not sufficient. See, amongst other things, the Supreme Court in Savas that we looked at last time, a sufficient link to mean that we are deprived of the sovereign immunity. So yes, my lady, we would say we are immune in that case, subject to one caveat, which is that if it was a non-perishable cargo, for which, and again, I'm not looking at the Act for present purposes, for which we had formed an intention to sell it after it was brought to the surface for commercial profit, then on a purely restrictive theory approach, I could see that that might be the cargo, but then had resumed a commercial nature. But whilst the cargo was simply on the seabed, it was an asset of the state, which at the material time, when the services are provided, could be put to commercial or non-commercial use, the same as credit standing to a bank account, as was considered by Mr. Justice Stanley Burton in the AIC case. And so, aside from the Act, my lady, the answer is yes, with that one gloss we would be immune. Applying the Act, the point is clearer in our favour, because the Act defines the relevant maritime venture. And I'll be coming on to develop this, obviously, in due course. In the present tense, as the Master of the Rolls pointed out at the last hearing, and therefore requires there to be, we would suggest, an ongoing maritime venture that the salvage relates to. And that comes back to the point which my Lord Justice Popplewell raised as to what is abandonment and what makes something a wreck. But the 2 concepts go hand in hand. And so just to flag up where I'll be going with that search. Something becomes wreck for these purposes when it is abandoned without hope of return. The concept of that abandonment is not only that it becomes wreck for the purposes of the MSA provisions, if I can cumulatively call them that for the moment, referring to the 1995 Act, but also that the common maritime venture comes to an end. And so the court has, for example, in the supplemental bundle of authorities, as well as the Lusitania, another case concerned with abandonment in the face of an enemy U-boat action, but in this case not sinking, which is Bradley and Newsom, which I will be coming back to later in. But in that case, the cargo owners were saying the vessel was abandoned, therefore the voyage was abandoned. But in fact, the ship was not sunk. She was recovered sometime later, taken to her port of destination. The cargo owners said, well, because you have abandoned the voyage, we do not have to pay you the freight. So in contrast to our case, it was not an FOB case, so the freight had not yet been earned until the cargo arrived. And the court said, no, there was no abandonment. And we may have to look at that in due course as to the distinction between what happened in Bradley and Newsom and what happened in the Lusitania. But in the Lusitania, we suggest the facts are much closer to our case, which is the vessel was actually sunk, whereas in Bradley, the German U-boat put a torpedo over the ship as a warning shot, a blank in fact, then fired a live torpedo astern, a live torpedo ahead, and then hailed the ship and invited the crew to disembark before they sank the ship. The crew disembarked. There was various other interaction between the crew and the crew of the submarine, and the crew then departed, assuming the ship was going to be sunk, but she was. And in that case, the court concluded no abandonment. But in the Lusitania, Mr. Justice Sheen concluded there was an abandonment. And so to come back to my lady's question, we would say that where the original commercial venture, if I can elide the two concepts, the common maritime adventure and the commerciality of it, has come to an end, the existence of an asset of the state, which is salved, is not sufficient to mean that the state is not immune as regards that salvage. So, my lady, as I said, it is important in that concept to bear in mind that the cause of action is Article 12 of the Salvage Convention. And the only intention we ever had as to the use of the silver, and of course this in one sense on the facts of our case is the other answer to my lady's question, is that we of course submit, as the court is aware, that our intentions in 1942 were not commercial. The only settled intention that ever was in relation to this silver was to use it to mint coin for predominantly, or for the greater part, for union coinage, which we submit is a sovereign purpose. And that therefore,
but that use doesn't matter. In the light of your answer to my question, it really doesn't matter whether you intended to melt it down for coinage or whether you intended to sell it to the highest bidder. You say there is a disjunct between the commercial venture, which was perforce abandoned or frustrated by the sinking, and the claim for salvage. So the natural position would be that in all cases of wreck properly so called, certainly where the venture's been abandoned, there would be a claim to sovereign immunity which would defeat the claim for salvage unless it was brought within your jurisdiction.
my lady, subject to the caveat I mentioned
Yes.
a while ago, that under a pure application of the restrictive theory, one might also consider whether a subsequent...
If it's brought up and you intend to sell it, then yes.
But you're going to explain to us that that's not an exception which arises under the terms of the Act. I think you're rather careful to confine your answer to what arises under the customary international law restricted theory, but it's not easy to get that exception within the wording of Section 10 of the Act consistent with your interpretation.
my lord, that is because under the Act, one has to look at the present tense venture as is ongoing, which might, and this is essentially our additional alternative ground, or alternative additional ground. It may be that under the Act, one could maintain a claim for immunity, even if one had formed an intention to use the cargo subsequently. And that if that were the case, then issues of disproportionality may arise that don't arise under a pure restrictive theory approach. And my lord, that's because under the Act one is looking at use or intended use at the time the cause of action arises, of both the ship and the cargo. So as I say, our submission is that under a pure application of the restrictive theory, and sorry, can I just come back to the point my lady made a moment ago, as to whether the intention in 1942 is irrelevant. On our case, obviously, yes, but I still have to maintain the submission about what the position was in 1942, lest my learned friend is right and what the position was in 1942 colours the court's consideration of use later. So in accepting my lady's point, it's on my case, yes, irrelevant, but obviously not irrelevant to the determination of here. So as I say, I was giving, I hope, a thumbnail sketch, and we say that applying the Act, we are also immune, not least because if one gives the words in use or intended for use for commercial purposes, their ordinary and natural meaning, as Lord Clark said, in so far as we have to. The silver was not, at the time it was salved, in use for commercial purposes. In fact, it wasn't in use for commercial purposes at any relevant time.
Well, your case is it wasn't in use for any purposes. It wasn't in use.
It was
lying at the bottom of the ocean and it couldn't be used for anything.
At least until it was salved and we formed an intention as to its use, and intended use would be sufficient. And there is support for that, and again, without turning everything up, just for this quick overview, in one of the textbooks in the Bundle of Authorities, Fox and Webb, at tab 31, page 722, all acts not amounting to a commercial transaction constitute acts in the exercise of sovereign authority. So if we're not doing anything commercial with silver, the simple act of owning it while it is an asset of the state is a sovereign act, so as to engage the restrictive theory. And so we would suggest that in this respect, section 10.4 does correctly reflect and apply the restrictive theory. And one can contrast it with section 4.2b, which the Supreme Court was considering in Benkarbush, that applied factors that required no consideration at all as to the commerciality of the relationship between the embassy employing the staff member and the staff members employed, whereas section 10.4 clearly does require the court to look at whether the cargo and the silver were in use for commercial purposes. And we also submit that we are immune under Article 25. And as my Lord Justice Popplewell has pointed out, I accept that I don't have any freestanding additional ability to get home under Article 25. And the reason for that is that Article 25 requires me to establish that the cargo is entitled to immunity under, I'll read it just to make sure I get it absolutely accurate. Under generally recognised principles of international law. And if I get home on the restrictive theory, that's why I said the restrictive theory is the generally recognised principle of international law for these purposes, then I have by definition established that the cargo is entitled to immunity under generally recognised principles of international law. And the importance of section 25, of Article 25, is that it says, unless the state owner consents, and there's no suggestion we have, no provision of this convention shall be used as a basis for the seizure, arrest or detention by any legal process of, nor for any proceedings in rem against, non-commercial cargoes owned by the state entitled to sovereign immunity at the time of the salvage operations. And so we would say that is good for a detention by the receiver, as it is good for a claim in rem against the vessel. The cargo cannot be detained in reliance on Article 12, i.e. the right to a salvage award granted by Article 12. Therefore, my learned friend would have to found claim to salvage somewhere else other than Article 12. And I'll come on to submit why we say he can't.
But your case on the Act, as I understand it, is that it makes not the slightest difference in a case of salvage of wreck whether the state cargo owner intends to use the cargo for commercial purposes, because the immunity is only lost, both for in rem and in personam claims, if the vessel is also at that time in use, and you say wreck, that has to be used by the ship owner, you say, it can't be used by the salvor, and in the case of wreck, it's simply not in use at that time by the ship owner.
Indeed, I don't shirk from that, my lord.
And that is, I think you accept, inconsistent with the restrictive theory of immunity under customary international law, do you?
My lord, I had this debate with my Lady Justice Andrews last time when she referred to, I think, what she referred to as an unpalatable consequence. It would be naive of me not to say that we do not recognise the argument that it would be inconsistent, particularly having not advanced that argument before. The point about the ship, which obviously I'll be coming on to in due course. But the way we would analyse the matter, and the answer to my lord's question is no, we would not accept that it was necessarily inconsistent. It is as follows. States are given immunity by the restrictive theory, save when they engage in commercial acts. I'm going to use the word commercial acts as a catch-all phrase, having got out of the habit of using the Latin. And so, save when they're engaged in a commercial act, they are immune. And for the purposes of implementing that restrictive theory, one has to analyse what a commercial act is. And using the Act, now State Immunity Act, as an illustrative tool, but not basing this part of my case on the Act, one can define certain transactions that are commercial acts for the purposes of the restrictive theory. So a commercial contract, as in Section 3, or an employment contract in certain cases, or torts in certain cases, or ownership of property. So various things the state can do that result in it losing immunity under the restrictive theory. In the Act, and indeed in various conventions as well, but specifically in the Act, one of the examples where immunity is taken away is, if I can call it this, I'm going to put a label on Section 10.4 and say engaging in a maritime venture. So you lose your immunity when you've engaged in a maritime venture, provided the maritime venture is commercial in nature. And the Act, essentially, if we could turn up the Act, because it may be useful to have it open, which is Divider 1 of the original authority. Page 5. How the Act works is, as I've said, in various subsections to take away immunity. And in Section 10, it's taking away immunity in the case of ships used for commercial purposes. I appreciate the heading is limited if any value, but that's the heading. So what we have is the draftsman defining a commercial venture by reference to the purposes of the ship. So if you are carrying cargo on a commercial ship, you have exposed yourself to not being immune. And that is why the purpose of the ship recurs throughout Section 10.2 and both parts of Section 10.4. So the question being asked is, are the parties, is the state involved in a commercial maritime venture? Has it shipped its cargo on a commercial ship?
So is it therefore engaged in a commercial venture, notwithstanding the ultimate use it wishes to put the cargo to, if it ships it on a merchant ship?
For the purposes of Section 10.4b, yes. And that exposes it, but only to an in personam claim. To be exposed to an in rem claim, it must also have an intention of commerciality in relation to the silver as well, because the in rem claim is what allows the claim to be brought against the silver. So my lady saw where I was going exactly, but what the draftsman has done is to define the commercial venture by reference to the use of the ship. And we can see in some of the international conventions the phrase used instead is a merchant ship, so a ship used in commercial. That brings you into the commercial playing field, as it were, but you are still immune from the claim in rem, provided you don't have the same intention in relation to the ship.
And tell me if you'd like to deal with this later or whatever, but what happened to the salvos claim in personam in this case?
My lord, it has been issued.
Yes.
My learned friend will correct me if I get any of this wrong. There was an application for permission to serve out.
Which was granted, I think.
Which was granted.
Yeah.
There was an application to extend time
Yes.
for service, which has been granted.
Yes.
So far, the claim form in persona has not been served.
And am I right in thinking that although a salvage, a right to salvage confers a maritime lien and is that's what essentially gives rise to the right to bring proceedings in rem, a salvage claim can also be brought in principle in personam against the owner.
A salvage claim can, in principle, be brought in personam against the owner, yes. A salvage claim does give rise to a maritime lien, yes, with one exception, which I'll come to develop this afternoon. It does not give rise to a maritime lien where the property against which the lien is owned is state-owned. State-owned.
But so if we're just looking at claims for salvage as a category, of course, section 10, at least 10.4b, is not so confined at all. But
peculiar, I think it is common ground between my learned friend and I that in practice it is.
Not 10.4b, surely.
Sorry, 10.4a. 10.4b.
No, 10.4b. So if you had a cargo put on a merchant ship, to use the Brussels Convention language, which is a state-owned cargo intended for purely sovereign purposes, then in cases other than salvage within 10.4b, which would include, for example, damage caused to the vessel by an injurious cargo, or damage caused to the vessel by negligent stowage for which the cargo owner was responsible, and I dare say there are others, there would be no immunity. The fact that it was intended for a sovereign purpose, the cargo, would be entirely irrelevant. 10.4b assumes that the only question is the use of the ship.
Indeed, because by being on a commercial ship, you're in the commercial venture, to come back to the point my Lady Justice Andrew raised, and therefore the state is liable on the claim in personam.
Yes.
Incidentally, parenthetically, almost certainly going to arise as a claim for breach of contract in the examples my lord gave, and therefore you would lose your jurisdiction, your immunity under Section 3 of the English Act.
Not if you're a Brussels Convention state, because Section 10.6 removes all the other exceptions to immunity, so Section 10 has to do all the work for a cargo owned by a Brussels Convention state, doesn't it? Even a contractual claim for salvage.
Sorry, we've now moved from the other claims to the contractual claims, but the answer is no. Because the reservation in relation to the Brussels Convention, the convention would do some of the work as well, if I could put the matter that way. So the convention, which I was going to come to this afternoon,
so I'm not sure you're understanding me. Suppose you have a Brussels Convention state which owns a cargo. Then the questions that we're considering, and a claim for salvage, is made against that state cargo owner. Now, the fact that it's a contractual claim for salvage makes absolutely no difference at all to the claim. The Section 10 has to do the work. You can't resort to Section 3 at all. So it's not as though we can put contractual claims for salvage completely on one side in deciding what Section 10 means, can we?
Maybe you'd like to think
I
about
was
it
going to say,
over lunch, Mr. Smith.
there are so many follow-ons. I think the answer is yes, because you would have, it's a pure claim in personam. But the point I'm struggling with is when you would have a claim in personam against a cargo owner not in the contractual context.
Or salvage. What about salvage, for example? There's a personal claim for salvage. That's 10.4b. It's not dependent on, in any sense, on what the cargo owner intends or is using the cargo for.
No, but it would be dependent upon either a maritime lien, and then we're back to claim in rem, or on the ability to invoke Article 12 of the Salvage Convention, and then we're back to Article 25, which comes back to my Lord's point, means that Section 10 isn't doing all the lifting by itself. Sorry, we wouldn't be back to Article 25 because we're not detained. I think I should have taken my lady's hint and thought about it.
But I think you may, because I'm not sure that the salvage claim does depend upon there being a maritime lien. That you can have a, I mean, if for example, let's take a concrete example. Suppose that your clients, the Republic of South Africa, were now to sell the silver to someone else and say, I no longer have a claim for ownership. I'm disclaiming any ownership in it. So far as the receiver is concerned, you can do what you like with it. Now, it may be that the maritime lien would attach to the cargo in the hands of the purchasers and still for the moment in the hands of the receiver of REC. That's one question. But the question I'm on is, nevertheless, would the Republic of South Africa still be liable to a claim in personam because they have had the benefit, subject to immunity, but just in general principle of a salvage claim, liable to a claim in personam to salvage because they were the owners at the time the salvage was made, and they have benefited from it because they've got the benefit of the value of the salvage in getting the full price for the cargo now. I think the answer may be yes, which and if it is yes, then a personal claim for salvage is not something one can simply ignore, as it were. We've got to fit the whole framework of salvage claims into 10.4a and 10.4b. No, we can't just look at 10.4a. That's the only matter I'm raising, and you may want to think about that. But, I see. I completely missed the time. You should have drawn it to my attention.
I thought I was assisting by finishing the point.
That's why I
taken the hits earlier.
When I say you should have brought it to my attention, it's not that it's your fault. It's entirely my fault. All right. Well, shall we say 2:15?